Next from Springfield, we talk one-on-one with Stephen Phillips, president of the Illinois Trial Lawyers Association. We get his perspective on proposed legislation that would expand the rights of citizens to sue for damages under certain conditions, and we get an overview of how trial lawyers operate their business and what criteria they use in deciding whether to take a case. This runs about 40 minutes.
Stephen Phillips, president of the Illinois Trial Lawyers Association. Thanks for joining us on the Illinois Channel.
Well, thank you for having me, and thank you for having the Illinois Trial Lawyers Association.
When we are talking about the trial bar, often everyone is infamous for telling lawyer jokes and complaining that lawyers sue too many people, and often they point their fingers at the trial bar as far as doing that. But I wanted to get beyond that caricature and get into your thoughts on what is the purpose of the Trial Lawyers Association, but also what some of the issues are that you may be focusing on as the legislative session is coming into its heyday here in the spring of 2014. Let's start with the legislature. What are some of the issues that as an association you're focused on?
Globally, one of the issues is, probably the major issue is, we want to maintain the right to trial by jury in the state of Illinois. And when I say that, the right to trial by a fair jury, an unbiased jury, an unprejudiced jury. And we want to make sure that the little guy, little people in the world, have the same access to the courthouse doors that big corporations do and special interests. That's globally our mission of the trial lawyers. Because the court system is the only place that the little guy, the Joe man on the street, has the opportunity to seek justice. And it's a really special thing. This year specifically, legislatively, we're focused on 4 different things. One is that we want to make sure that automobile insurance carriers are on the same level playing field as their insureds, their premium holders, their policy holders. And we want to focus on the fact that when a person makes a claim under their underinsured and uninsured motorist insurance policies, which they've paid a premium for that protection, oftentimes for many years, well, the contracts are written so that the policyholder has to demand arbitration. And there's 3 independent arbitrators appointed, which is fine. But the way the policies are written, that a policyholder can go through the arbitration process and spend money on depositions, on expert witnesses, on other witnesses, and gather evidence. They go to arbitration, everybody gets their day in court, so to speak, through the arbitration process. Everybody's heard, all the facts are on the table, but in many circumstances, after the arbitration award is rendered, the insurance company, and only the insurance company, is allowed to reject the award, of which they had agreed to participate in, and force the injured plaintiff to file a lawsuit. And that's something that we viewed as completely one-sided and completely unfair to the policyholder, the person who's paid the premium to the insurance company.
Now, who came up with those rules that it would be that way?
People don't realize that insurance policies are contractual. And when an insurance company issues a policy, people generally don't read the fine details of the policy.
And if they do, they probably don't understand it.
Exactly. And what it does is unilaterally, the insurance company can reject the arbitration award if they think it's too high, and force the plaintiff to spend money, file a court case, go out, go through the legal process in the courts, despite the fact that they've already done that in arbitration. By the way, the policyholder, if the award is too low and he or she is unhappy with the award, they do not have that option to reject it. Doesn't sound fair.
I know you said 4, so I don't want to get bogged down in one. What are some of the other points that you're focused on?
One of the other areas that we're pursuing is presently if a person is rendered disabled, mentally disabled, as the result of an accident, or as the result of medical negligence, or lawyer negligence, or any negligence, construction negligence for that matter.
Would it have to be deemed negligence?
Well, as a result of what's called...
Could someone have a stroke and be mentally disabled, or is that not?
Well, that's where we're going to get. Right now, the way the status of the law is that if the tortfeasor, the wrongdoer, renders somebody mentally incompetent as a result of their negligence, the statute of limitation is stopped. That claim does not run, the person does not lose that claim so long as they are mentally disabled. If they become competent again, the statute of limitations starts running. Well, there's a loophole, and it's a loophole that happens very rarely, but it's very severe when it does, that if a person, for example, an accident victim, an injured person injured in an automobile accident, 8 months later, 10 months later, becomes disabled as a result of a stroke, something unrelated to the accident, and they're rendered incompetent, and nobody catches the fact that no lawsuit was filed, they would lose that claim. So right now the trial lawyers have said what we want to do is that whether you're disabled as a result of the tortfeasor's negligence or some other disability that occurs afterwards, we don't want the tortfeasor to escape having to pay for the damage they caused, which is what the present state of the law is. As an example, and it sounds complicated, we had a man who was injured in an automobile accident, and his family took care of him for 1.5 years and tried to negotiate the claim with the insurance company directly. Then the man had a stroke. And while the family was caring for the stroke, the statute of limitations had run and they never went to a lawyer because they thought they were going to get the claim worked out with the insurance company. Unfortunately, the statute of limitations had run, and it had run because no one had contacted a lawyer within the 2 years. Well, they were busy caring for their disabled father from the stroke, which is what they should be doing, and the original driver, we couldn't file a claim against the original driver from the original accident because the statute of limitations had expired. And it's just wrong. If he had injured him from the beginning and caused the disability, he would be held liable. By sheer luck, he got off the hook, so to speak, because of the technicality that the person was rendered under a disability, a mental disability.
And what are the other two that you're looking at?
The other two is when corporations cease doing business, we want to make sure that they leave a registered agent available to receive service of process. For example, if a corporation, their conduct is negligent, we want to make sure that when they cease doing business, there's still going to be insurance that's going to cover the negligent acts of the corporation. We want to make sure that the injured person can still collect the insurance that was available prior to the time that the institution closed down.
I want to come back to that one, and number 4 is what?
Number 4 is an interesting and very harsh result when people hire safety committees to come into factories and workplaces to give opinions about safety recommendations and
Kind
safe
of as
machinery.
a consultant.
A consultant.
Okay.
What happens is that if there's an explosion or someone gets hurt in that factory because of the negligence of the safety consultant, there's a law that says that the safety consultant doesn't have to answer in court for the negligence, for the injuries that their negligence has caused. Because they can come in and say, well, wait a minute, I'm under the workers' compensation insurance policy of the employer. Technicality. You can't sue me for my negligence, and the only remedy the worker has is under workers' compensation, where the benefits and the claims that are due, the damages that are due, are significantly lower and not fair and not full compensation for the injured person. So we're going to address that when the consultant doesn't pay any of the insurance premium, doesn't have anything to do, they shouldn't be allowed to benefit from the employer's workers' comp.
On the corporation aspect of it, if a corporation closes down, one would think that typically they would be closing down because either economic reasons, they can't make a go of it anymore, so they're closing their doors, or perhaps somebody was incorporated and they retired. Where would the financial assets come from to continue to pay an insurance policy to have a liability program in case they were to be sued after the fact? And for how long would that policy have to be in effect?
Well, for the time period that this bill is not dealing with insurance per se. There's insurance out there and that's covered by different bills. This strictly has to do with how we can get the corporation into court to find out if they do have insurance or assets and how much. This is just...
And right now you can't get them in the court, or is it?
When there's dissolved corporations, there's an awful lot of hoops, calisthenics I call them, to get through just to find out insurance information and any asset information. And this tends to come up oftentimes with latent disease cases where there's some type of conduct that causes a disease or latent disease down the road. And we just want to make it a bit easier to make sure that we can get the information about insurance assets to find out what's out there potentially for the injured person.
When you represent someone and you would allege negligence, as you were talking about, and your fourth example is an example, or any number of cases, I guess you're suing someone because, well, frequently because it might be negligence. Who defines negligence? Who would say, whether it's the consultant, as you were talking about, or in some other case, who is to say on that question of negligence that there was negligence? Is that the court ultimately? But even as far as just the bringing of a suit, how do you determine if someone was negligent to bring a suit to begin with?
Well, negligence has long been defined as what a reasonable person would do or would not do under the same or similar circumstance. And that's a general good definition. In that scenario, that's what we have to prove in a court of law. There's precedent through other cases, and when lawyers look at determining whether to file a claim or not, they do it with the eye of looking under that standard, that definition, with whether or not they can prove the claim. And I'd just like to add that we've heard the phrase frivolous lawsuits for years and years, and trial lawyers do not file frivolous lawsuits. We can't afford to. We're going to hold a case for 3 or 5 years. It's a long time.
Is that a typical holding period?
Yeah, absolutely. Maybe longer. And we're going to spend an awful lot of money trying to get justice for our clients. It is not unusual for a trial lawyer in a complex case to not only hold the case for 3 to 5 years, but to put in anywhere from $100,000 to $300,000 of our own money into a case on behalf of our clients to make sure that we can potentially prove their case. So if we're going to work on a case for 3 to 5 years, and our office overhead, I'm a small businessman too, continues to run with salaries, my insurance costs, my rent, neither me or any trial lawyer wants to end up on the losing end of a case that shouldn't have been filed. It's not in our interest. Now, the reason that our fees are often contingency and that we charge a third is because, and I say this to my clients frequently, I say the insurance company lawyers are getting paid $250 to $500 an hour. And at the end of every month, they send a bill to the insurance company for $5,000 to $10,000. Would I be able to send you a bill at the end of every month, despite the fact that you're hurt, you're not working, you got medical bills, you got bill collectors after you, and I'm the lawyer now who you hired to seek justice for you is sending you a bill for $5,000 to $10,000 at the end of every month?
So you're going to take cases, one would think, I don't want to put words in your mouth, but you're going to assess the case as a business person and as a lawyer and say, is there a reasonable expectation that you can win a case based upon the facts as they were presented to you and whether or not there were negligence? So I think you would say that you're not going to take cases where you don't perceive there to be negligence, otherwise you'd end up wasting your time and money.
Absolutely. And the trial lawyers are against frivolous lawsuits. And we've always been. Hang on one second, if I may.
Go ahead, sure.
I just think that the word frivolous, it goes both ways. And what the public never hears about are frivolous defenses to legitimate lawsuits. And the public never hears about the fact that when there are legitimate cases filed, that oftentimes the insurance companies will file defenses that are frivolous. And cases go on for years in an effort to wear down the plaintiff into accepting less than fair compensation. And I can show you a significant number of cases, which we have here at the trial lawyers, where these frivolous defenses, where cases are settled after years on the courthouse steps that should have been settled years before and resolved. And the public never hears about those frivolous defenses. And I think if the public were to read the examples that we have and what really goes on in the court system at times, this word frivolous goes both ways.
When you hear people talking about the trial bar, what is a common misunderstanding that people have about your industry?
One, frivolous lawsuits. Number one, I hear that a lot. Number two, I often hear that we're ruining business in Illinois or impairing business in Illinois. I live in a fairly conservative town, and I'm often at weddings or dinner functions, and people will come at me, "What do you do?" "I'm a trial lawyer." And you would think that I'm public enemy number one. And when I start telling them the facts, rather than the myths, rather than the perpetual story after story that just keeps spinning, they look at me and oftentimes, "Wow, I never knew that." "Really? That's how things work." And I tell them, for example, right now workers' compensation is a big issue in Illinois. And I tell them, I said, "Do you folks realize there's over 330 workers' compensation insurance companies writing business in Illinois? And in this hellhole, in this bad place for business?" Well, these insurance companies, these 330 insurance companies are climbing over one another to collect premium dollars from employers. And I tell them with regard to workers' comp, back in 2011 when the workers were asked to give up long-held rights, they said, "If you think this is going to lower insurance premiums, you're naive. But what we're going to do is we're going to ask you to put in the bill transparency in insurance premiums. And we want an industry watchdog, not consumers and not the trial lawyers, monitoring the payouts under the new law and monitoring insurance premiums." And as the workers predicted, this year, the watchdog, the industry group, recommended a 14% decrease in insurance premiums to employers for workers' comp, because they said that the insurance companies have saved over $350 million as a result of these changes. And you can imagine what the insurance industry said. "Nope, not going to happen." Another common myth that I hear all the time, because I do a fair number of medical negligence cases, is that doctors are getting sued right and left. It's not true. And I said, let's talk the facts for a minute. This is all public data, by the way. In the last 10 years, medical malpractice filings are down by 40% in the state of Illinois. That's huge, 40%. And profits are way up in the malpractice premiums. They have record profits, the insurance companies. Another huge myth that I've told people.
Of course, we had the 2004 change in the law that then the Supreme Court threw out as being unconstitutional. But would you say of any of those changes relative to the medical malpractice suits being brought, was that any kind of a change in behavior by the trial bar? And I'm trying to anticipate what someone who would disagree with you would say. Because the bill was like a warning shot across the bow of the trial bar to say, don't sue as much as you did in the past? Or were there other reasons why we had a 40% drop?
The main reason is, and I can say this because I was chairman of the Medical Negligence Committee for 7 years for ITLA, and I've also been a lawyer who's done this for 29 years. Medical malpractice cases are incredibly expensive. A simple one plaintiff, one defense medical negligence case I have to budget $80,000 to $100,000 out of my pocket to give my client the ability, expense-wise, to try and prove their case, to give them an opportunity. They're very, very expensive. And that's the driving force behind medical negligence. I should say the main driving force.
Do you find any, one of the things I point out to people when we get in conversations, just as you said you did about the trial bar, and because I've covered a variety of issues, I have a little more insight than maybe the average man in the street, but it seems to me certainly the trial bar is out there and will do to the good side. Sometimes we are nickeled and dimed by an industry. Maybe they are charging us $10 a month on something that they shouldn't have been charging, but they're doing it to 1 million people. No one is going to go to court to get your $10 a month back for the last year. But I would say, that's where you could bring a case, whether maybe it's a class action lawsuit, to make sure that that industry no longer does that, because collectively a trial attorney can make some money out of that and have the behavior changed. There's also regulations typically from government, but there's often not enough regulators to go around just to make sure that people aren't taking advantage of consumers. So again, I would say to the good side, you have the trial bar often kind of being there as the unofficial cop on the beat, because they will go in and bring a suit if they find some aspect of behavior going on within an industry that needs to be corrected. So that's, I think when people understand that, they would say, yeah, I get that. But I think they find that sometimes maybe is the net ever on negligence cast too broadly so that we get the guilty people, but we also include people that shouldn't have been included in a suit. How does one determine negligence? We talked about that a bit, but if, let's say there was a bus accident, we might say the bus driver was at fault, maybe the bus company was at fault for some reason. Would you look to sue the manufacturer of the bus, or how do you draw that line to say, here's who we target on a suit and here's who we don't?
One always looks and says, after an investigation, after anybody does due diligence, you have to look and say, what is the evidence? What did my investigation reveal? What have I found out as far as who is responsible and why, and how strong is my evidence? And after doing that investigation, a lawyer has to ask, do I have a good faith basis for bringing a lawsuit against this potential person or company? And what people have to remember is that when a lawyer files a claim, cases are thrown out by a judge. A plaintiff's lawyer may be subject to sanctions, monetary sanctions for filing an inappropriate case. And again, I go back and say, why would a lawyer who is going to be shelling out an awful lot of money out of his own pocket want to pursue a claim that isn't meritorious and he probably isn't going to recover? So there are multiple steps in this procedure, multiple safeguards to make sure that the person who shouldn't be sued is either A, isn't sued, or B, is dismissed at some point once the evidence is out that shows that he or she is not responsible. Candidly, no one wants to be sued, but the way our justice system is set up, it says you have to provide information sometimes to determine whether or not you did engage in some type of conduct that did cause harm to this person. And the best example I can get is last night there was a recall on an awful lot of cars produced by General Motors from '04 to about '07 or '09. And General Motors apparently, based on the written records, knew about this and didn't recall these vehicles and didn't let consumers know. And a lot of people died and a lot of people were injured. And now, once full disclosure, once the evidence came out, GM is now apologizing to people that they were too slow in responding to the problem with the airbags in the ignition system in certain cars. So this continues to go on. I will say this, that with regard to defective products and dangerous products, in my career, I think it's pretty obvious to me that the actions of trial lawyers have made products safer. Lawyers now filing product liability suits, there's just a handful of lawyers that really concentrate on those now because there aren't as many dangerous products as there used to be when I started this practice 29 years ago. And we've made product safer for consumers because now manufacturers look and say, maybe I better get a safety correspondent in. Maybe I better get a consultant in to look at this product to make sure it's not unsafe or dangerous for consumers.
Do you ever, individually or as an association, do you ever just send a letter out to someone and kind of saying, kind of a heads up, we think that you're having negligence? In other words, are you ever proactive rather than reactive? Do you ever say to somebody, hey, we noticed here's some problem that you might want to address before it becomes an issue?
Absolutely. And I was trained by my father, who was a lawyer for 50-some years, and he had a saying that it's much better to have a fence at the top of the hill than an ambulance at the bottom. So when we see things, when we see issues, we absolutely let people know. And in fact, I have seen, when I've been in hospitals, for example, when I've seen conduct that I think is going to lead to some injury or potentially hazardous, I've alerted the general counsel of the hospital who I may have a relationship. I think you should take a look at this. I think you should have a talk with this person. I'd much rather see people safe and people healthy than have to represent them later on. Because candidly, and I say this about all my clients, every one of our clients would much rather have their health than any money. There's no question.
How much of the, speaking of health, and I think when the issue of the Trials Lawyers Association was at its zenith, and at least in recent memory, was back in 2004 when we were engaged heavily in the medical malpractice debate. Is there any, do you know the numbers off the top of your head? I'm just curious. How does it break down as far as caseload? Is it suits involving transportation, suits involving medical malpractice, suits involving maybe being ripped off by some business practice? Is there any pie chart of what a typical or how typical cases are within the industry?
I'm so glad you asked that question. That's a myth that I've had to dispel to all my friends over the course of the years. Globally, and this is a statistic that I think is very telling, about 70% of all lawsuits that are brought in the civil justice system are businesses suing other businesses or individuals for money. Contract dispute types of things. 70%. About 20% or so are domestic relations, divorce, child custody, things like that.
No, but as a trial attorney, you don't take those kind of cases?
No, we do not. We represent injured people.
I guess my point was within the kind of cases that you would take, I didn't know what a breakdown would be.
Oh, I'm getting there. I'm getting there. Tort cases, injury cases, make up about 6% of the cases that are filed in the court system. About 6%. Very low, to say the least. Within that, the vast majority of those are automobile accidents, things like that. Of that 6% globally, only about 5% of that 6% are medical malpractice cases. So when you break down that pie chart and you look at 100% of the court cases, 6% are tort cases. 5% of those, that 6% are malpractice cases. You see that the numbers are very, very low as far as medical malpractice, for example. Product liability cases are significantly lower than that. I don't have those numbers, and unlike my opponents, I'm not going to make up numbers that I don't have.
What would you, I mean, is there, what would be the preponderance? Do you know offhand?
Oh, I would say automobile cases.
Automobile,
Yeah,
okay. It's just
yeah.
Someone driving in a negligent way and causing some injury.
Or truckers. One thing that negligent trucking cases, truckers drive over the amount of hours they're supposed to have. There's on-duty hours, off-duty. There's log books. And people don't realize that trucking accidents are often due to being overworked by their employer and fatigue. That's why we always look at log books. And we always look at log books against the receipts of where they're buying gas, where they're making phone calls, where they're paying tolls, to determine if the log books are accurate.
On the other hand, a famous incident, I would say, that is in the news now and may be happening again, and it goes to the point you were making when you talk to people and the mythology, and people were saying that you're always suing every people. But as a society, we can become victimized in ways that we never anticipated. And so one of the famous cases is having your credit card ripped off through a department store that maybe didn't have the security. On one hand, the department store themselves are victims of criminal activity, but perhaps they would have had some degree of negligence if they should have known that their credit card processing was more open to being hacked than it should have been. Is that an example of a kind of case where there's a new area of law that your association members would be going into?
I haven't heard anybody talk about that, mention it to me personally. I would hope that the manufacturers or the retailers or whoever's holding credit card information or personal information is going to beef up their security. I had a chat with a security expert over the weekend with regard to that issue, and he said that he had predicted it along with a lot of industry insiders. But as far as the trial lawyers, I can't speak to that because I haven't heard from members.
Before we close out, how is your industry? What's the health of your industry? Are more people coming into your industry? Is it getting harder to practice? How would you assess it now?
That's an interesting question. Unquestionably, our industry is, and in fact, I would say our profession, because I don't like to think of it as an industry. Our profession is always difficult because we are constantly responding to the manufacturers, the United States Chamber of Commerce attacks, well-moneyed attacks on the civil justice system and the laws, because it's their mission right now to see if they can pollute or bias the public against trial lawyers and against injured people. And so in that sense, our profession has gotten very difficult because they're much more organized now and they're relentless with their daily attacks. And they never let the public know that 6% of cases are tort cases. If you buy into their constant daily rhetoric, their constant daily attacks, one would think that 90% of all lawsuits are injury cases, when just the opposite is true. And they perpetuate the McDonald's coffee cup myths, for example, which that's one of the things as the trial lawyers that I've explained to people how that happened and when they hear the facts. When people hear the true facts about the coffee cup case, their eyes open up and they say, wow, I didn't know that. And I'd be more than happy to share that with you if we had time. That lady was not driving the car. She was sitting. The coffee spilled on her when she opened it up. She had third-degree burns in her crotch. And I've seen the pictures, and I show people the pictures. It looked like she had battery acid dropped in her crotch. From her crotch halfway down her thighs, it looked like she had battery acid. She got hit with 180 to 190 degree coffee, which on your body, all the burn experts will tell you, you have 5 to 7 seconds to get that coffee off. Industry standard is 130 to 140 degrees for coffee. And when that coffee spills on someone, they've got about a minute to get it off. Their clothes, pull it away, take off their clothing, whatever. Well, McDonald's had had 700 prior incidents of their coffee spilling on people and causing serious burns. Kids, seniors, people who weren't quite perfect and happened to spill some of their coffee. But they kept their coffee that hot because it would last longer. So the jury heard all this evidence common jury under the 7th Amendment of the United States Constitution, right to trial by jury, and said, you know, we're going to give her $480,000 of compensatory damages. And we're going to reduce that by 20%. I'm sorry, I take that back. The jury gave her $200,000 in compensatory damages. 200. And they reduced it by 20% because they said 20% of this accident, despite the fact that this coffee was scalding hot like acid, was her fault. So her award was $160,000. And then they turned around and said, you know, McDonald's, you did 700 prior claims, and we're going to penalize you with punitive damages for $2.6 million, which represented about 2 days' profits from coffee sales for McDonald's. That's where the numbers came from. And the judge turned around and said, you know what? The $2.6 million in punitive damages is too high, and he reduced that award to $480,000. Those are the true facts behind the McDonald's coffee cup. Not that a lady just spilled a cup of coffee and got $1 million.
I know we could go into a lot more details and talk at length, but relative to one of the points that you had made right off the top, that you wanted to maintain the jury trial by jury or decision by jury, why is that under threat? What's afoot that we would not have trial by jury?
Well, there's a big push by the United States Chamber of Commerce and insurance companies, number one, to put arbitration agreements into an awful lot of contracts and to send cases like this to arbitration. There is a huge push to enact special laws, special legislation, to impair the ability to bring a claim to a jury and impair the evidence that the jury will hear. And then to put caps on damages and say, you know, juries don't know enough. Juries aren't knowledgeable enough. We want to put arbitrary caps and set damages at a fixed amount regardless of the evidence and say to the jury, this is as much as this injured person is ever going to receive. And that's a threat to the jury system. That's the right to the constitutional right that taxpayers have to seek redress in the court system that their tax dollars fund.
You know, you just brought up, and I apologize because not to go on too long here, but when one goes to a stock house, almost any stock brokerage company in America these days, you basically have to sign a form that says you're going to have to go to arbitration, that you're not going to be bringing a suit through the courts, which is a bit of signing a contract under duress because it invalidates some of the rights that you don't know before the fact how you might have been injured. I mean, look what happened with Bernie Madoff as an example. No one went into working with Bernie Madoff knowing that he was going to be engaged in criminal activity and engaged in thievery. To what extent does one have to, if you sign these agreements, whether it's a stock brokerage or any other industry, saying I'll go to arbitration, do you have to live up to that, or can you get a trial attorney to say it's somewhat invalid because there's really no other option for the person to even get into the services, goods and services, if they have to, they didn't really get a chance to negotiate that aspect?
The vast majority of these arbitration agreements are upheld, and you have to go to arbitration.
And I'm not trying to put words in your mouth, I mean, is that basically a good process or not a good process?
It's, number one, it's a process that most people are not aware of because typically it's either in fine print or it's a process people don't understand. For example, you put your elderly parent or loved one in a nursing home, and now the nursing homes are throwing arbitration agreements into these agreements. And that takes away a constitutional right that our forefathers fought for and thought was very important with regard to the foundation of this country. You know, the 7th Amendment, the right to trial by jury, is the only thing that really keeps everybody in check And there's an awful lot of people that never want to be in front of a jury having to answer to jurors with regard to their negligent conduct when they know they've done something wrong and they don't want to face the jury. But that's what our forefathers suggested was the best way.
Is there an aspect of the level of grievance? In other words, let's take a nursing home. If someone wants to sue because they got served some food that maybe had gone bad and they're, had food poisoning and were sick for a while, that might be one thing that you would go to perhaps arbitration. If, on the other hand, a nursing home hired someone who had a criminal activity and ended up doing physical harm against a patient, would you still have to go through arbitration, or is that a level to which it would invalidate and you could bring suit?
That's a slippery slope to start picking cases of this one should go to arbitration and this one shouldn't go to arbitration. As I say to people, that's...
I guess I'm asking, can you pop that veil of arbitration? Is there some outlet for the consumer, in a level of between venial sins and mortal sins, so to speak, as you might say, depending upon the grievance, the level of grievance?
As the law exists now, the answer is no. And I would suggest to people, that's what I call selective constitutionalists, that certain people are allowed the rights under the Constitution, Seventh Amendment, and will make the decision whether
Would it be people, or would it be just a level? In other words, like the difference, as we say in the law, between misdemeanor and felony.
No,
the law would still apply, but it all depends how it's applicable, not necessarily to whom.
Our concern as the trial lawyers would be, who's going to decide that? Who's going to decide what level of harm should be heard by a jury, should be allowed the constitutional protection of the Seventh Amendment, and who's not? And the problem with that is that people are selecting who should be given the protections of the Constitution and who shouldn't. And that's just not right. The right to trial by jury has been around for a long, long time since this country was founded, and it's served this country well. And to go place arbitrary restrictions, someone says, well, I think this person or this level of harm deserves it, but this one doesn't, would violate those principles.
As we close out, what would you say to someone who's considering about going into your industry?
Go into this profession for the right reason. Either be a student and a scholar, or go in to seek justice, go in to help people, go in and do this for the purposes of doing good for the rest of our population. Because what I found over the course of my 29 years, as I get a little older and a little grayer, is that I take an awful lot of satisfaction when at the end of the day, I've helped somebody who was the underdog. I've helped somebody get justice who was faced with a bleak future, was faced with mounting bills, and was getting the stiff arm from the wrongdoer. And it's a very rewarding experience over the course of a career.
All right, well, Stephen Phillips, we appreciate you taking the time to talk with us.
Thank you very much for having us, and remember the right to trial by jury.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.